The Jones Act law. A Jones Act negligence claim requires a lower burden of causation than other negligence cases. Most other negligence cases require proof the negligence of the defendant served as the primary cause of the injury. To prove causation for the Jones Act, it is only necessary to establish that the defendant's negligence played any part in causing the injury. No matter how small, damages can be recovered if negligence contributed. I-Stock 1,185,646,669 minutes scaled. The level of your negligence, while not serving as a bar for recovery, influences the size of recovery. Compensatory negligence by you reduces the recovery by what % you were at fault. If you were 40% negligent in causing the injury, then you will recover 60% of the reward. Death under the Jones Act. Deaths over 3 miles from the shore are covered by the Death on High Seas Act, DOHSA. This act caps recovery to quantifiable damages. For seamen, this would include lost wages or other benefits they earned from their employment. If a death occurs within 3 miles of the shore, then the Jones Act will cover it. Deaths covered by the Jones Act law receive monetary damages such as lost wages, but also include other benefits such as funeral costs, future wages and other benefits. Absolutely no cost to you unless we win. The lawyers at Doyle Dennis LLP have vast experience in offshore claims and understand numerous federal maritime laws, such as the Jones Act law, that apply to offshore claims. Our Texas firm works every day to help clients across state lines and international borders in their maritime accident claims. Getting maintenance and cure. Maintenance and cure provide necessary help after an injury. After an injury, it is important you follow the appropriate steps to secure the benefits. First, it is important to report your injury to your supervisor as soon as possible. You should then seek appropriate medical care to diagnose your injury. The next step is to file a claim. Claims must be as soon as possible following the injury. With the claim, you need an official accident report that contains the details of the accident. Supervisors and employers may be reluctant to file claims, but if you are injured while working, it should be a priority. Securing this claim allows facts to be established. As soon as you face any trouble or want advice, it would be wise to seek the legal and practical guidance of an experienced offshore injury attorney at Doyle LLP Trial Lawyers. Even if you are not aware, numerous guidelines and deadlines exist for claiming compensation. To relieve confusion and stress, it would be wise to contact an experienced attorney to walk you through the process. We have worked with injured maritime workers all around the world, and will treat you with respect and care through negotiations and litigation required to seek to obtain maintenance and cure. When maintenance and cure is willfully denied, longshoreman rights. Doyle Dennis LLP has a solid knowledge of longshore employees and other maritime workers' rights. Through analysis and investigation, we can understand if you have a Jones Act, LHWCA, or other maritime case and how to maximize your recovery. We can also evaluate the cause of your accident to see if a claim against a third party allows for recovery of damages. Our success in hundreds of trials and settlements in serious injury and fatal accidents allows us to ease your worries in challenging times. Contact us at 713-571-1146 to talk with experienced longshoreman lawyers and start your claim today. What does the LHWCA provide? The heavy machinery and sophisticated equipment associated with many marine jobs creates risk for injury and in some cases even death. The Longshore and Harbor Workers' Compensation Act aims to provide medical care for workers to help them recover from their injuries and financial compensation to ease the loss of work. The combination of the medical and financial compensation is necessary to ensure workers can recover adequately and maintain financial stability. The Act gives injured workers the right to medical care, including doctor's appointments, hospital visits, surgical and other procedures, and rehabilitation services. The medical care will continue until you are able to work again or maximum medical improvement has been met. Maximum medical improvement occurs when an injured employee recovers fully or further healing does not appear possible. Workers also have the right to choose their own qualified physician. Financial compensation in the form of 2/3 of your average weekly wages until you can fully return to work or maximum medical improvement is made. Compensation is subject to the minimum of 1/2 the national average weekly wage and maximum of twice the national average weekly wage.